Okay, welcome back. Welcome back. Give everybody a moment to get back with us. I don't know what the weather's like there. It looks sunny behind Kristen. It is torrential downpour here. I'm like, get me out of here. Get me to the beach where it's nice and sunny. So anyways, hopefully we're going to be okay with the internet connection and all that great stuff. All right, so let's continue on. We're moving a little slower than I planned, which is totally fine. So we'll just kind of go at whatever pace makes sense. And if we don't have time for both hypos, that's fine too. You can always use them as team exercises, but we might be fine. I don't know. All right, so I'm going to go through some just kind of tools and thoughts about your role as an investigator. And as I said at the beginning, a reminder, again, there's no one way to do this. I'm going to give you some suggestions and food for thought, but these are just tools for your toolkit. So if you take the trauma-informed training through Title IX or go to a more robust trauma-informed training, you know, you'll get a deeper dive into some of the concepts I'm going to weave throughout here. But I always say, again, they're just tools. You be you in your investigation. Use whatever makes sense given what is presented to you from a party. But I will tell you what we always say is the number one skill for an investigator is to be curious. So you want to always be asking yourself in your head, you know, why, and digging deeper on the particular issue you've been asked to investigate. But I also like to say, as Ted Lasso says, be curious, not judgmental. So it is easy to hear certain things and want to immediately have a judgment in mind about what you're hearing, and also not nosy. Be curious, not nosy is something Betsy likes to say. So it's easy to go into rabbit holes and get off on things that don't matter. And so I'm going to talk about that a little bit as well. First things first, though, I want you to be thinking about the atmosphere. So if you have 3 folks who are going to be doing the investigation together, where is that going to take place? Is it virtual? Who's going to be the leader of the 3 of you? Because that is overwhelming. If you think about a student coming in with 3 administrators who are going to investigate and interview that person, it's also the same way for an employee. You want the atmosphere to be comfortable. It's okay if it's professional, of course, but not too formal and not intimidating. So one thing that we like to do, or we've done with institutions, we do these large scale audits of kind of their Title IX programs, is an aesthetics kind of audit. So what does it feel like when someone walks into the Title IX coordinator's office or what have you? So as a team, when the 3 of you get an investigation, really thinking about from the outset where you're going to meet with these parties and the witnesses. If it's going to be virtual, that's fine. But of course, this is what I do at the beginning of our trainings is something that I want you to think about mirroring as well, which is if you're in virtual land, like what happens if you go away? Think about that party who's sitting there and they're in the middle of an intense interview with you, and then you disappear because the internet goes out, or one of you disappears and the other 2 don't, or something like that. So really setting the stage in that atmosphere and thinking about it from the very beginning. And then thinking about your introduction. So when we have in-person trainings that are longer, I have folks practice their introduction, because if you're shaky on your introduction, it creates nerves for everyone. And it sounds so simple, but I can tell you this can be hard. So who's going to be your lead, which I believe is probably someone, I think, Kristen, more seasoned, who's maybe doing most of the conversation, and you all are going to be there to watch. But even our most seasoned folks, sometimes we get comfortable, we forget something. So what does your introduction look like? And explaining your role as an investigator, not as professor so-and-so or employee so-and-so, like who you are, why this interview is taking place, your qualifications. It's up to you if your lead person wants to get into all of that. It's something we've started adding in some of ours because we keep getting the question. Who is a participant, asking what they prefer to be called, not only pronouns, but maybe their name is like Charles and they prefer to be called Chuck. You know, maybe it's something completely that's not in their name. So that helps to add to that comfort level. You know, it's okay to establish a little bit of rapport. and asking, thinking about what they do, where are they from. It's okay to be human. It doesn't have to be just straight and narrow. I'm here for this. We're going to do this, and then we're going to do that. Asking if they have any questions or concerns before you launch into those substantive questions. So going through that introduction, and then asking if they have questions kind of about the process or anything else. How should they let you know if they need a break? Do they have a hard stop time? So sometimes you might block off an hour and a half, but they're right in the middle of telling you the most intimate, difficult part of what you're interviewing them about, and all of a sudden you got to stop. So do they have a hard stop time can be a really good question to ask. I have 2 slides on the introduction because I think it's so important, but they really, a lot of the concepts overlap, but just remembering that you're wearing a different hat than your university employee hat, and them understanding your role, that you will ask hard questions and talk about difficult topics. You'll provide breaks if needed. You will keep information private, but that's different than confidential, because the parties have the ability to see each other's information as you go through that review of evidence, and the expectations for them to tell the truth and consequences for failure to tell the truth. Kristen's saying in the chat bar, you all have a script for this that she's gonna, I imagine, provide you at some point. But I want you to really be, so, and I know you'll do this, but I just have to say it. Before you got into the investigation, she's saying you'll have a prep meeting, which is amazing. Not every campus gets that, FYI, to start thinking about those things, because you don't want to go in cold. You don't want to walk in not having thought about what your script is going to look like and how you're going to explain things. And you want to also explain who else is in the room, what their role is, these other investigations. Are they a potted plant and not going to say anything? Are they going to ask questions? The feel of that investigation and the comfort level of that party who's already going to be nervous starts from the minute they walk in the room, and that's where trust starts. And if there's no trust, you're not going to be able to get all the important information you need from that party. And that is an art. It's not there's no hard science to it, but these are just things to think about as tools in your toolkit, and that I know in your prep meeting, Kristen will go over with you as well. I had something else that I wanted to mention. In your introduction, it's okay to acknowledge that this is difficult. I want you, though, if you start saying things like that to parties, to make sure you're saying it to both of them. I've sat in a lot of hearings and investigations where when the complainant is there, I'm so sorry, this has been a difficult, I know this has been a difficult process, and then the respondent walks in and everything's very cold and harsh. So, it's okay to have empathy. It's okay to have, to be, again, a human, and to say, I know this is, to acknowledge that this is difficult, but we want to, again, do that in an equitable manner with both of the parties. Trying to think of what else. For complainants and even respondents, something else to think about is acknowledging that they may have had to tell this information multiple times. The complainant may have, met with Kristen already, or Aaron, or whomever, and said some of these things in order to get that information in the formal complaint. There might be an ongoing criminal investigation, and they're having to talk to you again. And that can lead to a lot of frustration out of the gate that you did not create, but that's brought into your situation. So that can be helpful. Just trying to think of anything else. Okay. And I don't know if you all provide the policy and procedure to the parties again during that process or not. Flowcharts, showing them where they are in the process, all can be helpful. And it's good to go through those things at the beginning to kind of help everybody kind of calm down, everybody being the parties or the complainant or respondent, and ease some nerves. So all things to consider. There again, with interview skills, there's no hard and fast rules. It's okay, and we encourage you to develop rapport. You want to be observant, you want to be professional, and we always recommend that you do outline your questions at the outset. What things are you going to want to ask about, but that you have flexibility. So all of us on my team do this differently. Some of us have like an actual outline of order. Some of us, like myself, kind of like to have points that, like in the formal complaint, and dates and things like that, that I like to think about. I like chronology and thinking about things in order. And so if there's multiple events, I will tell a party, we're going to start with talking about the October event, and then I want to move to the December event or whatever. So kind of keeping it chronological can be helpful. We encourage you to ask open-ended questions. So yes, I have who, what, when, why here. I don't like why as a starting point. That's a really attorney thing. It puts people on the defensive. When I say to my kids, why did you get a bad grade on your Spanish test? They're like, oh, blah, blah, blah. They shut down and they don't want to answer me. And they're like, I'm in trouble. I don't want to answer. If I say, help me understand what happened in Spanish, they're much more likely, yeah, well, I studied, but I didn't study that hard. I like to use this on my husband and my as well. But, you know, it helps in everyday life. Help me understand, or tell me where you'd like to begin, or tell me how you'd like to start. Really giving the agency and control to the other party. That does not mean they're just going to be a fountain of information. At some point, you may have to drill down and start asking the hard questions because they may not be as comfortable sharing. But starting off very open-ended can be very helpful. I have here the circling technique, which is the lawyer thing, but I like to mention it. Again, something else that I tend to use on my children and my spouse. So if someone doesn't want to talk about something, say they're not really answering your question, maybe it's just too difficult for them, just let it go for a while and then come back. If you just keep asking the same thing over and over again, they are going to continue to shut down. So maybe you ask and they completely evade the question. I like to circle it in my notes or star it, and I'll just come back to it later when maybe they feel more comfortable with me. Or maybe they'll never answer it and you will have to ask that hard question. But something, just another tool to think about. Again, I like to work in timelines. So I might start very open-ended. Tell me where you'd like to start. And that person may speak for 30 minutes or longer without interruption. You know, you're just going to take your notes and you're going to let them talk. And then I go back and I try to go in, maybe they're not in chronological order. They're jumping from this party at Christmas to something that happened last week and then back and forth and back and forth. And so I'll try to go back and establish that chronology and start asking the more detailed questions. But it's okay to just sit there and let them talk. It is, I like in person to talk about strengths and weaknesses of investigators, and for you as yourself to think about it. I know people on my team, some of their weaknesses are they have no poker face. And I'm like, okay, you've got to just stay as neutral as you can with your body language and your face, no matter what comes out of someone's mouth. And I like to talk and I like to interrupt people in this general role in my life. So I have to really tell myself, like, just sit here, just sit there, let them talk. Silence can be really helpful, and not try to always fill it, because when they have a little bit of time and some silence, they might continue to share. So just thinking about all those things. I've already talked to you about openings, but I can't say it enough. And then also thinking about what you're going to say at the end. We always want it to be open, an open door policy when it's over. Hey, if you think of something else, you can always reach back out to me. You wanted them to feel comfortable, because in that moment, they're nervous and they may give you everything, or they may think of something else later. I honestly see that more with respondents sometimes, because they've been given all these allegations against them. They're trying to think of all the things. And then later they're like, oh, there's something else I really wanted to tell you. But that can happen with witnesses or the complainant. So I always like to keep an open door for an opportunity to provide clarification. We've also had situations where, and I don't like to call it lying, I think that's a really harsh word, but we have had situations where parties are not being truthful and it's very obvious. And so, we've come back and said, I feel like, I feel like there's inconsistencies in what you're telling us and maybe this video that's like very obvious. If you want to come back and meet with me again and maybe give me a different account, that's okay. So sometimes it's okay to call things out, but I don't want you to call anybody a liar or try to paint them in a corner because you see a big difference in what they're saying. Again, not an adversarial process. Yes, you're trying to elicit all the information, but sometimes you just got to be patient and they will come back to you. And in that more significant situation, we went back to that party and said, would you like another opportunity to meet with me? it was Betsy. And that person said yes and came back and said, okay, I wasn't fully truthful. I was nervous about XYZ. So we just had to give them some space. It's hard to be patient because you've got this deadline and you've got all these things you need to be getting done as an investigator, but it's okay to take a breath and bring someone back in. You want to, you're trying to be as trauma informed as possible, meaning not interview them 100 times and get everything you can in one interview. However, there's just gonna be times when circling back is necessary. When I do kind of our level 2 trainings, I like to talk about leveling up in soft skills. So, yes, we're giving you a lot of information on some things to think about in your toolkit as a human, and a lot of you already have this skill set in the role that you're in for your institution. Really, the soft skills, Celeste talks about this a lot, are what are critical. So yes, you need to know what you're investigating. So in the Xander Charlotte example, you're investigating stalking. You're going to be trying to elicit information from the parties to help your decision maker determine whether or not stalking occurred in violation of your policy. But the soft skills are really what are critical to developing that rapport and making the other party feel comfortable. Stay professional, of course, but it can be helpful. And then I also want you to be thinking about trauma-informed practices with everyone you're working with. So not just the complainant, but also the respondent and also the witnesses. So in that trauma-informed training that's in Title IX University, I go into this a little bit deeper and you can take that anytime. But a lot of the things I'm putting in here are from that training or food for thought in kind of a condensed version. But being trauma-informed is not necessarily mean you have to be a forensic psychologist or all of those things. It just kind of means remembering that everyone you come in contact with most likely has experienced some type of trauma of some sort, especially post-COVID in their world, and that everyone responds differently to trauma. And sometimes within 1 hour, they may respond one way and 1 hour another. And so when you're meeting with them, a lot of times that trauma is coming into your time with that individual. And so they could be angry, crying, completely shut down and clammed up and not willing to speak to you, and everything in between. And that doesn't mean that they're necessarily not telling the truth, that, they may not remember things in sequential order. That does not mean that they're trying to play games with you. It just might mean they're struggling. There's going to be something in the spidey sense in you that something's going to tell you at some point someone is trying to play games with you. That can happen, okay? But at the same time, a lot of times they just can't remember. And later on are like, okay, I remember something. So we like to say with trauma-informed, the number one skill is adaptability and leading from the person that you're with, okay? If they are nervous and anxious, I'm not saying you be nervous and anxious. I want you to be the one that's calm, cool, and collected and chill. But using empathy, listening actively, that's a very hard skill, in my opinion. Developing that rapport and withholding judgment, but being adaptable. Some opening initial questions that can be helpful. What are you able to tell me about what happened on blah? Where would you like to begin? But hitting them with 5 questions at once is going to be very overwhelming for them. So you want to kind of stay open, chill, but it's okay. Like in human, you're going to ask bad questions. Like you're going to ask questions that don't come out well, especially on the hard topics. Just be transparent. Like, I might get things wrong. I might ask things in a way that's not appropriate. I might call you by the wrong name accidentally, whatever it is. It's okay to be human. And when it happens, just say, you know what, I'm sorry, I didn't ask that very well. Let me try again. That is okay. Some trauma-informed framing the question examples. We tend to want to say, if somebody didn't ask for help and there's people around them, why didn't you ask for help? A better way to ask it might be, was there anyone else around that was available to you? We have incapacitation cases where someone saying, well, I didn't want to drink. And you want to be like, well, then why'd you drink? So trying to go away from that. Well, what happened after you had that drink? Or I will be honest with you, I've asked this many times and wait, did I stop? Oh, whoops, I didn't mean to do that. I did not stop recording during the break. Sorry about that. We're still going. Okay, sorry. I just had a panic for a minute. Okay, here we go. So why didn't you report right away? So this is something that I've asked in investigations, why did you report now? Because the respondents a lot of times will say, well, look, this complainant waited 5 months, as something to use against them. So I learned from Betsy a better way to ask that question. Was there anything in particular that helped you decide to report? Because it can be important that they have now decided to report and they didn't report 6 months ago. But you want to just think about the way in which you frame that when asking the complainant, assuming the complainant is the person who brought it forward. As I've said, you want to treat the parties equitably, but interview them uniquely. So again, all the baseline introductory questions you want to have as basically the same for your complainant, your respondent, and your witnesses, including those protections against retaliation. But when you're interviewing them, they're still individual people. So you do want to interview them uniquely, ensure that both of them are being taken seriously in whatever they're telling you, that there are no prejudgments, that you're always given that reminder of their prohibition against retaliation to all the parties. And again, that you are not afraid to ask hard questions, but acknowledge that they are hard. The reality is you are going to be doing work where you're talking about sex. You're talking about the most intimate thing that might have happened to this individual ever. And you're having to get some details sometimes when it comes to sexual assault allegations about a sexual and intimate encounter. That is something that, I don't want to talk to my best friend about necessarily, much less a complete stranger that's sitting, or 3 strangers that are sitting there in front of me about whether a condom was used and, all those things. So note that you're going to have to ask hard questions, and you need to be comfortable with that as well. And it might be that you don't understand something. I will say, I don't understand. I mean, I've learned a lot about things like Snapchat, all that. But it's okay to say, like, I don't know what you mean by that. Could you help me understand? Help me understand is always a good going back to. Some other rephrasing of questions. I've told you about help me understand. It's my favorite. I always like to add at the end, is there anything that I haven't asked you that you would like to tell me? That's always a good closing way to end. Are there any witnesses you want me to talk to? Do you have any additional information to share? When you feel that you're not getting a lot of feedback on something, can you tell me more about that? Just keep saying that over and over. Can you tell me more about this or that? And questions for clarity, completely appropriate. But the why questions, I would be careful of. Leading questions. So again, you're not in a court of law. Like, didn't you go to the bar at 6 a.m. on Friday? Now, sometimes I'll help them out when they're like, the complainant might say, I think it was, I don't remember, like they're getting stuck on something, but their formal complaint says it was at 6 a.m. I might say, your formal complaint says 6 a.m. Is that still accurate? Oh yeah, that's right, or something like that. Blaming questions, of course, we always want to stay away from, and interrogating questions. So again, all just part of kind of that trauma-informed thinking. What types of evidence and information are you collecting? Are you trying to gather? So we like to break it down this way, which is your direct evidence or information is something first person observed. So Kristen was talking about earlier kind of rumor and innuendo, and I'm going to get to that in a minute when I go through this slide. But direct evidence is something someone has personal knowledge of. They saw it, they heard it, they witnessed it. Is it the most accurate information? Not always. Everybody has different perceptions of something that occurred. So it's really for your decision makers to weigh what they think is the most important in making their determination. But as an investigator, it's good to know, I will tell the parties, do you have any other witnesses you want me to talk to? And then I will say, look, and what is it that you think that they're going to add to the investigation? Because if they're like, well, they're just going to talk to you, like, I want you to talk to Sally Joe because they know me and know that I would never be dishonest. Well, that's a character witness. So I might want to manage expectations with that complainant of, hey, I'm going to talk to Sally Joe, but I really want, if there's anybody that witnessed this incident or has direct knowledge, something like that. Circumstantial information or evidence can be just as valuable. So one example would be direct evidence is I look outside and I see that it's raining. Circumstantial would be my daughter walks in, she's wet, she has an umbrella, she's shaking out. I can infer it's raining. That's circumstantial evidence. So it's reported observation of information that offers inferences about the facts of an event is the official definition. And then you have your documentary information or evidence. So it could be a police report or a write-up. Hearsay information. So it is hard to describe anything as other than hearsay, like those rumors or innuendos. But I always tell folks, just forget about hearsay. So advisors are going to be like, it's hearsay. I don't want you to tell them that. I wouldn't even get into it. It's like you just circle that party back to any kind of direct or circumstantial evidence they may have brought up to get clarity, but they're going to tell you all kinds of things that are hearsay. I would be really reticent to be like, oh, stop. I don't want you to tell me anymore. That's hearsay. Just let them talk. And then when you get to your report writing and you're trying to cull out what is included as relevant information, then you're going to maybe think a little bit more through what was said. But it's basically information reported through another party. It's a legal term that applies in the courtroom and in a court of law, but does not really apply in this context. And then the regulations allow parties to bring forward expert information or evidence. And so you could have someone say, I want you to talk to this person about the effects of alcohol on the system of 110, pound female drinking at this rate, and all that kind of stuff. As investigators, what I would say is help your decision makers out by trying to establish what makes them an expert in what matters. So what are they coming forward to talk to you about? And what are their qualifications for that? You don't have to make a judgment one way or the other as to whether or not they're a good expert or not. That's going to be for the decision maker. But if you've got somebody who's an expert in bees and honey, and they want to come and talk to you about incapacitation, that's not going to make a lot of sense. Again, if they're wanting to bring a quote unquote expert, most likely Kristen's going to be involved from a procedural standpoint. Yes, she says no outside research. But so just something to think about without getting in the weeds too much. Other evidence, videos, social media, text messages, Snapchat. I know Snapchat goes away or people are worried about taking a screenshot of it because the other party can see. You can take a screenshot of it with your phone if you need to. Applications and other. Go ahead, Jessica.
I'm sorry to interrupt.
You're fine.
Whenever we were talking about the intro, I believe you said that sometimes there will be like an expected end time. Are these interviews usually, or is it better to have it just be open-ended, they go as long as they can, or set a time frame for them?
I don't know what you all do in practice, or go ahead, Kristen. I didn't know if you had something. I don't want to say anything different.
I was going to say, we typically try to schedule. So me and Erin work on getting the schedule together for y'all and what's provided for like who they think we should witness to interview and the parties that need to be interviewed. We typically try to schedule those on Fridays. And then once you've interviewed them, if you feel like you need more time with them or you need to circle back to them, we kind of act as that liaison. So all the communication comes through us in scheduling all of that. So that it's less burden on y'all and your other responsibilities at the institution. If it comes to like, if you feel like as a panel, you need to talk to an expert witness, or you have questions about some of the stuff that's being provided to you as data or evidence, we always request that you come to us with that so that we can appoint somebody. So you're not doing any outside research that the parties are unaware of, and they don't have an opportunity to see and vet that person coming in and talking.
Okay. And is there, do y'all typically schedule an hour or some amount of time, or it feels like there's a lot of information that we're trying to gather, and I know that you'll have some witnesses or some parties that speak more or less, and I don't know if there's any value in sort of not cutting it off or in trying to extract more information if the interview is just not going anywhere after 15 minutes, if you have somebody who's just not really giving much details.
Yeah, so we kind of do like a timeline. After doing an intake session and conversations with both parties, we kind of get a feel for if some parties are more chatty, for lack of a better word, than others. So we'll give like a time frame of when the panel will be interviewing them. And typically we do the complainant in the morning hours and then the respondent in the afternoon hours, and any witnesses the complainant has will follow them, and same with the respondent. And like I said, if we ever feel like they didn't get an opportunity to tell everything, or they feel like there's more that they want to talk about, we can circle back around and reschedule them for a later time. But yeah, we try to do them on Fridays because that's when we have the most flexible in student scheduling as well as faculty and staff.
Okay.
I think blocks of time is helpful because it manages expectations, and you could be there forever with certain folks.
Mhm.
So it's helpful to have a start and end, in just to have it for everyone's sake. And it sounds like Kristen's kind of doing that work at the front end to kind of say, okay, this is probably going to be a long one. Like, we're going to do a bigger block.
Yeah, and they get a copy of that time frame too, so they know when we're planning on reaching out to witnesses. So they know like, oh, we're getting close this time. They're about to call some of my witnesses. I'm going to take a break. And if we feel like we need to revisit with them, that's when we typically reschedule for them to be able to come back in for a later time or later date. Erin, did you want to say something?
Hey, sorry. Yeah, I was going to say, one of us is always in the room with y'all, kind of procedural control, right? And if you've got questions or if something is happening, so let's say you were interviewing the complainant and they were really getting into their story. They were talking, they were being very productive. And we saw that maybe in 2 minutes, we were scheduled to stop and interview the next person. We could always push or reschedule the next person too, so that you don't lose that flow, right? And that's the beauty of the block, I guess, of time, right? But again, Kristen and I are always, one of us is always in there with you so that you're not having to make these decisions on your own.
Yeah, I typically sit in on the interview because Erin does the initial intake. And then when if it goes to hearing, then Erin sits in on the hearing. So there's no crossover of who's in the room for which part.
And are you all doing these virtually or only in person? Or
we have done them both virtually and in person ever since COVID. That's now an option that's on the table.
Yeah, virtually has worked really well for us, but it is something that's good to know, like, that you've practiced or whatever. And if they have advisors, then they want to go talk to them, like figuring out breakout rooms and all that can be good. But I'm sure they'll go over that with you at the outset, but just something to think about. Very different interviewing virtually than in person. It's harder to read nonverbals. So if someone's getting tired and needs a break, or if maybe they don't have as much privacy as they need to, you really got to be on it as the investigator, or if you're on the team. And I know if Erin or Kristen in there, that's really helpful because they can watch for this too. All of a sudden you see a kid, running back and forth. We've had complainants interview us in the middle of the quad with us, and we're like, are you sure this is a good time for, you know what I mean? They're like, hey, and then they're coming back. And so, just thinking about all those things, you never really know what you're going to encounter virtually. Hopefully it'll be fine. But the other thing, like I said, is I think it can be really helpful. It's less intimidating for folks, but at the same time, it is hard to read those nonverbals if they're getting tired or they're getting emotional. So being really cognizant of that, and just like breaks in person, making sure they know from the outset how to ask for a break if they need one is really important. So definitely adds a little bit to the skill set you need to be thinking about when you're virtual. Okay, so, I wanted to go back here really quick. So videos are really important. Hopefully your school is going to be pulling them when they exist early, because most schools are on a loop and they go away after a while. So that's like immediate, something you want to be getting. Applications can be helpful. There's a lot of physical evidence. So we want you to think outside the box, especially employee on employee cases. There's things sometimes we don't think about. And Kristen's saying that loop for video is 30 days. So you want to get it as soon as possible. Sometimes it's just gone and there's nothing you can do depending on when the report came in. You also, witnesses, you're going to be thinking about eyewitnesses, that direct evidence and information. Do you allow character witnesses? Asking the parties if they have witnesses they want to add, an expert. So Kristen, what do you all do with character witnesses? Or
I
Erin?
don't typically take character witnesses.
So good information to know as an investigator. Whenever we have an affinity group, sports team, fraternity, sorority, something like that, and other times too, but it never fails, they want to bring in lots of people as character witnesses. So being clear on the type of witnesses you will talk to and won't talk to establish, that manage expectations, as I like to say, can be really helpful.
A lot
And
of
then
times
just-
I was going to say, a lot of times we stipulated on what that person will provide to the investigation. We'll ask them that on the front end. Like, was this person there? Is it someone that you talked to? What are they going to be providing for the investigation? And if it's just a character witness, or it's just one of my friends, or then we typically say, they can provide a written statement if you want to bring it in, but they're not necessarily going to have to interview them. But typically we don't take them.
I like that. There are times, there's exceptions to every rule. All right, so just a reminder that parties can have an advisor throughout the process of choice. Your policy is going to define how they can be involved. I believe your policy says they can be there but not speak on behalf of the party. Am I right? Yes. And they could be an attorney. They don't have to be. So a couple things, and you're not going to forget this because y'all have a lot of checks and balances. But number one, remember, your parties are your complainant and your respondent, not anyone else. So witnesses want to bring in somebody, all that, that's a no as an advisor. Now they're very different than if they need an accommodation, a disability accommodation or something like that. Totally different than your advisor. They can be a pain. It's going to be more of a pain for Erin and Kristen than for y'all, most likely, but you never know. But you want to make sure you don't forget to copy them on all the things that you got to do with your reviews of evidence and information. They can also be helpful because they are the person who is the quote unquote advocate for that party. The university and you might be the enemy, but that person, if they understand the process, can actually be helpful as well. So just food for thought there. But as I said, it's okay to give them parameters. And if they can't follow those parameters, if you've got Erin or Kristen in there, then they're going to help you out here. Then it's okay to not allow them to participate. Now, I give them a lot of rope, but we have had several occasions where we've said, you're no longer helpful to this process. And so you can no longer participate in it. And so, there are some that use some tactics that are pretty gross and disrespectful, and we want you to know that that's not okay. And so we're not going to allow that. But you do want to set expectations for the advisors and what their role is and communicate that often and clearly. So I tend to give a little bit of rope to advisors because you have to remember, and I'll say this at the end too, talking about advisors, this is a new process for them as well. So some attorneys are being difficult and some just don't get it. Like their job is to advocate for a client. So that's what they're going to try to want to do and interrupt and talk for their client. So I give a little bit of leeway sometimes there, but remind them, hey, please don't. It just kind of depends on what's going on. I think you all do already have, rules of decorum. Thank you, Kristen was reading my mind. So sometimes that lead investigator might need to remind them of that, or Erin or Kristen if they're in there with you. But you want to allow time for the advisor and the party to talk to each other if they need to. So you don't want to have a chilling effect on that. It is a big deal to become between a client and their lawyer. So that's the rub you're running into. So you just want to, if they need a break to talk and confer, totally fine. So make sure you're just establishing that comfortable environment. And again, it is new for a lot of them. So just being patient, just go into everything knowing you just have to have your patience hat on. And I'm not a patient person, PS. So just go in there and it's like, okay, that you have to be in a different place, mental place when it comes to these things. And if there's advisors you want them to have that time. And then anything that you can have in writing, make sure to include the advisors in. All right, any questions up to this point? Y'all been great about asking them as we go, but I just want to give you a minute to breathe, see if you have any other questions about kind of what we've gone through so far. Everybody good? Hanging in there? Okay. All right, so again, and you'll see this at the end, you all are not serving as decision makers, but it's still really important that you understand the standard of proof that you're working off of that's in your policies and procedures. So remember, you're investigating a violation of your policies and procedures. It's not a criminal investigation. And your decision maker, your hearing officer, is going to be making a determination whether there's a preponderance of evidence or not to support a violation of that policy. The preponderance of the evidence is 50% plus a feather. It supports it or doesn't. Doesn't mean it didn't happen necessarily. It just means there's not enough evidence to support it if there's a finding of non-responsibility. So as investigators, as you're asking questions and you're looking at the formal complaint and the notice of allegations, if you're investigating stalking, you really want to have a good command of that definition so you can ask questions to elicit responses to help your decision maker decide if there's a preponderance or not. It's a very different standard of evidence than a criminal investigation. So we have a course in there that you can take on parallel processes with the criminal and the school process. So, if you have any questions about that, that's something to watch, or listen to one of our podcast episodes on it, because the standard of evidence in a criminal case is much, much higher. Respondents often, when there's simultaneous processes, want to come to you and say, hey, I was charged criminally and it was dismissed, so this whole case should go away. You have to constantly remind them that they're completely separate and distinct processes. And there's a lot of reasons why a criminal case might get dismissed that have nothing to do with the school investigation, for example. So without getting too much in the weeds on that, I just wanted to point it out and just encourage you, if you want a better understanding of that, certainly ask or kind of go to those resources. But when there's a parallel process, you can expect there might be some pushback from the parties. And then the report. So I talked to you earlier about strengths and weaknesses of investigators, and everyone has different ones, right? Well, on my team, I have certain folks who love writing reports, like Amy, who's coming back in right now, thank goodness, and others who freeze when it comes to that time, right? It's a lot. You need a block of time. They can be very lengthy. I'm pretty positive that you all have a report template, right, Kristen, to work off of, which is very helpful. You're going to want a lead person to be the one that bears the burden of writing the most of it, but it's really easy to freeze just because it's a lot to do and you all have other jobs. So I want to encourage you, just block that time and get to work. Reminder that your report content is going to include how it was reported, the formal complaint information, who investigated, the policy that's implicated, your timeline of events, and I would encourage you to be working on that timeline as you go. It is not fun at the end to have to recreate when you interviewed people and when they, when you followed up with them and things like that. So if you can do that as you go, that's really helpful. What information you got from the parties and witnesses, any physical evidence, and then all the regs say is you're going to do a summary of relevant information. And then oh, that's amazing. Your system maps timelines. Yippee. And then note for your records, any information that you decide not to include or witnesses you didn't interview and why. So we always say, and I can't remember if it's in here, investigate as though you're going to be investigated. And I know that sounds scary, but you just want to document as though somebody picks up that investigation report, knows nothing about it, and can read it and it makes sense. So I put this in here because your decision maker, this is their checklist that they're going to have to do, your hearing officer. And this second one, they're going to be getting that information from your investigation. So that's why we kind of hammer home having the description of the procedural steps that were taken, including if you yourself use some method to gather information or evidence, like you decided to go to the residence hall and look at the path, or walk from the bar to the wherever they went. you want to make sure that's all in there and included so that the parties know what happened in the investigation. And then of course your decision maker has that. You also want to think about your audience. So these reports can be lengthy and very formal feeling, and that's fine. But you don't have to throw in legalese or complex words. You know, I like to say, talk in the active voice, not passive. It keeps things simple, and just stick to what needs to be in there. And if you think about it from the standpoint of who's going to read it, so anywhere from a student who's 18 years old to a judge, if this ever got challenged, right? So the beauty of it is you have other folks laying eyes on this that are investigators. That can be really, really helpful in keeping things kind of clean and organized and all that. So speaking of organized, again, you've got this all mapped out in your policy template, but just how you're going to organize it. Is it by event? Is it by party or witness? Is it by time? When you have a really complex investigation with multiple incidents, sometimes it might make more sense to do it by event. Sometimes it might make more sense to do it by party, which is generally what we do. Information we got from the complainant, information we got from the respondent, information we got from each witness. But you may have to make that mix that up depending on kind of what you're dealing with. And so just a reminder, that report has to fairly summarize relevant information and evidence, be provided to the parties and advisors, and can be in hard copy or electronic. So let's talk about relevancy. The spoiler alert that you heard in the course is that the regulations do not have a specific definition of relevancy, but they do tell you 3 situations where information or evidence is definitely not relevant. So the first is treatment records, unless the parties agree. Privileged information, like between their lawyer or their physician or something like that. And then questions and evidence about the complainant's prior sexual history, behavior, predisposition, with limited exception. It's offered to prove someone other than the respondent committed the sexual harassment, or it concerns specific situations between the complainant and the respondent, and it's being offered to prove consent. So if it's one of these 3, it is not relevant unless it falls under those exceptions, and you're not going to put it in your report. Now, this has come up some, and you guys have, again, a lot of checks and balances where it shouldn't be an issue, but we've had complainants give treatment records, for example, with their therapist, not really understanding that that's going to be shared with the other party. So you got to be really explicit. If they want to hand you treatment records and say, hey, I want to give this to you to show the impact this has had on me and my mental health, then you need to get that, waiver from them that they're okay with sharing it. And they need to understand it's going to be shared with the other party. We've had it on the respondent side too. So a couple of things I want you to think about, because remember, your report is going to be a summary of relevant information and evidence. So anything outside of those 3 things that I just went over with you is fair game, meaning it's really your discretion as the investigator whether to include it or not. What helps take the pressure off is that ultimately the decision maker has to weigh relevant information and evidence and make relevancy determinations and all of that. So if you decide something is not relevant and don't include it in your report, it's still going to be in the investigative information directly related to everything, and your decision maker is going to get it, and they can make a decision as to whether or not to put it into the hearing. As a general rule, I tend to be more lenient than not as an investigator when it comes to relevant information and evidence. But here's some things to think about. So again, during the investigation, kind of what I just said a little while ago, Xander provides you with his treatment records to demonstrate he's experienced anxiety from Charlotte's behavior. In that situation, not relevant unless Xander signs off on allowing you to use it. So I will want, you're going to want to get that agreement before you go forward and use it in your investigation. If Xander says, I want you to know this, but I don't want it in the investigation, it's not relevant because you don't have that approval, okay? So you're not going to put it in your materials. Does that make sense? All right. Next one, Charlotte informs you, hold on, I gotta move things on my screen so I can read it, that Xander is a cheater. She gives you text messages she received from another girl, Sally, that are between Sally and Xander, and they purportedly show Xander was cheating on Charlotte. So this is the example we had before. Charlotte's been accused of stalking by Xander. Charlotte now wants to show you, investigator, and tell you how Xander is a cheater and a bad person. And so she wants to give you text messages that she received from Sally that are between Sally and Xander to show that he's a cheater. So remember, there's two 10-day periods of review during your investigation. One is to review information directly related to the matter, and the second is to review the report. So my first question to you is this information, so she hands you these text messages, is that going to be in the directly related to review of the report of everything? So the directly related to is before you write your report, although you're probably going to be writing it during that time, and it's any information directly related to the investigation. Would you be including these text messages? What do you think? NECA thinks no, I think, based on her shaking of her head. I'm reading those nonverbals, or I'm trying to, and again, this is an okay place to, there's no right, wrong, and different. So, but what do you all think?
I would say no, just because it's about past sexual behavior, and it's not pertaining to the allegation.
Okay.
That would be my guess. I don't
understand how it's related to like Charlotte being accused. So like if Xander was accused of maybe doing something or transmitting a sexual transmitted disease or something like, that would help show where maybe that came from. It has nothing to do with what you're being accused of. So it didn't validate the fact that you're stalking him or you being accused of stalking him.
Okay. Anybody else? And let's say Charlotte's bringing this up to justify her behavior. Okay, still a no. Anybody else have a thought? So remember, and this is only my opinion. Kirsten could disagree with it. So this is the 10-day review period before you write your report, where the parties have the ability to look at everything directly related to the allegation. So what I would probably say is in this phase, if she gave it to you as the investigator, I would let Xander review it. But when you get to your report writing, is it relevant in your report? I would agree, no. Now, again, you could say, I'm not going to put in the directly related to. I would be okay with that too. But probably if I'm handed it by a party, I'm an investigator, she's dumping all this information on me, it's probably just going to be in there. I don't know that I'm going to call it out for the directly related to piece. Now, Kristen, do you help navigate that directly related to review, or Aaron?
Yeah, so we actually have a separate website we post all the provided materials to. And then, so it would be made available for parties to review everything that's been provided. Granted, it would be stated what is like the investigative panel will state in the report what evidence they included for their relevancy assessment, or that they felt was relevant to the facts of the case. So they can see like, this is the stuff that was included, this is the stuff we excluded, because it gives them the opportunity to, in their 10-day review period, argue why they feel like that was relevant and need to be included. But the other party would need to see what that is to understand what the argument is, if that makes sense.
Yes, exactly. So Chuck and NECA and all of you really are on the right track from a relevancy perspective, but I did this to you, not to trick you, but just to show you that at the end of the day, the parties are going to see everything for the most part, unless it's a treatment record, let's say. You're not going to put it in there if you don't have a waiver. They're going to see everything so that exactly what Kristen said, they have the opportunity to say, hey, I do think that's relevant. Charlotte could then argue back in her written response, that's relevant information. And then you as the investigative team could say, well, I'm not convinced by Charlotte's argument. I'm not putting it in the report, or I am convinced, for example. We've also had, I can't remember if I have another hypo for you or not. Nope, I don't. We've also had, we have had situations where someone is offering, let me go back to this, where a respondent is bringing forth information about prior sexual history in order to show that pattern. Like every time we've had a sexual encounter, X, Y, Z has happened, and this is why I thought I had consent. And so, we've had that happen, which is an exception to that third relevancy thing. So just something to keep in mind, not gonna be hard and fast prior sexual history, and it's only prior sexual history of the complainant. So that is a distinction only because if the complainant wants to say, we've had complainants want to say, that respondent has a reputation for being a player. Is that really relevant? Does it make a fact more or less likely to be true? No, but it doesn't fall under this exception. So it's still okay to say it's not relevant and not put in your report, but it doesn't, the rape shield protection, which is what this third prong is called, is only applying to complainants. So we geek out over these things on my team. And so when Betsy called me when we had the first time that we ever had this, it was offered to show a pattern. She's like, oh my gosh, I have an exception in an investigation. Like we're dorks, but it does happen, but it's not very often. So just a reminder there.
Can you restate that? Because you said something and then I completely missed over that. So that last bullet point.
So the last bullet point, evidence of the complainant's prior sexual history, by and large, is never relevant. So if you take the Xander Charlotte example, and Xander is our complainant, then Xander, Charlotte can't say, well, Xander has slept with 10 other people. Because Xander's a complainant, by and large, not relevant. But if Charlotte, if it was the allegation of, sexual assault, and Charlotte wanted to argue, she says, hey, Xander and I did things this way every single time, and that's why I believed I had consent this time, that might be allowed because it's an exception to this. Or if Charlotte wants to say, actually, Xander did that with somebody else, she might be able to bring that in as to show it wasn't her that actually engaged in that act.
I have
That
another
makes sense.
example too that might be helpful.
Yes, go, Kristen.
So like we've had cases where prior discussions have happened between the parties on like what kind of things that they would like to try sexually, like kinks. And then those discussions, the respondent or the person who is alleged to have violated the policy felt like in those discussions gave him consent to do some of the things that happened later that she was then saying that he didn't have consent for, because he was able to show, oh, we have all these text conversations of how we discuss what she was willing to try, what I wanted to try, when we were going to do this, where we've actually discussed this. And then now that I've done it, she's saying that I didn't have consent to do it, but I was under the impression I did. And then she didn't use the safe word. So like, that's where we've kind of had like an exception to them being able to bring in past relations between the two of them.
That's a good example. Okay, so any other questions, feel free to chime in. Y'all are doing awesome. Okay, so credibility determinations. I just wanted to bring this up as well. By and large, again, this falls on your hearing officer, but just a couple points. So one definition I've seen that I like about making credibility determinations is it's a reasoned analysis based on the evidence. So it is not based on personal characteristics or the role of somebody as a complainant or a respondent. You want to be considering inconsistencies in statements, discrepancies between statements and evidence, or when something is corroborated. Someone says this happened and someone else corroborates they saw that happen, right? I hate credibility determination. I think they're really hard. It's hard to call someone basically a liar or say they weren't credible. For your purposes, you might be highlighting what facts are disputed and undisputed, but you're not, by and large, I don't think, are you, Kristen, making credibility determinations as the investigator? No, okay, well, Aaron's saying no, I think that's right. So, okay, but it's good to understand. It's hard, I think, because investigators have so much interaction with the parties that they really understand their personalities more than a decision maker. I've had situations where a respondent was really credible. I mean, just by and large on how that person interacted with me, and then got in the hearing and got really defensive and did things that, you know, caused the hearing panel to feel like they weren't credible, that had nothing to do with the evidence, basically, or vice versa. So it's, I don't know, it's hard. I think that's a very hard thing to do, but it's good for you to understand that this is what the decision maker is going to have to be doing, and they're going to need to be doing it based on the evidence, not a feeling. We've had to talk down a lot of hearing officers when we've talked to them about a case they're deciding, and I just know the respondent did it. Okay, but you've got to have evidence. Like, what evidence supports that? Where's your feather? And, you know, I don't see a feather in all of this, and you're finding them responsible. So that's why it's so imperative that you all as investigators are doing a thorough job, thorough within reason, but a thorough job to get as much information as and evidence for your decision maker. So I put this example in here. Xander states that Charlotte, same example, followed him to class one day and then berated him in the parking lot. Charlotte states that they rode together to class and got in a fight in the car. So two different accounts. The university pulls video footage of the parking lot during that time period. And the video shows Xander and Charlotte arriving together. So we have an inconsistency on between evidence and Xander's statement, right? Something that tends to corroborate what Charlotte's saying, they went together to class, versus what Xander is saying, which he's saying she followed him and then they got in this fight in the parking lot. So that's a very simplistic example of something, you know, where a decision maker would say, we've got corroboration of this and not of this, and so the evidence isn't there, without saying Xander lied about X, Y, Z. Okay, one more thing, and then we're going to take a quick break because I know we've been going for another hour. But the burden, I cannot emphasize enough. I say one more thing. Let me go through these. The burden, again, is on the institution. Yes, you're going to ask the parties for anything they want to give you. You know, if one of them gives you text messages, you're going to try to get all the text messages, for example, because people tend to only share selective portions of text messages that are beneficial to them, right? But the burden is on you, but it doesn't mean you can't ask for information. But if you have access to it as an institution, you need to be asking for it. Also, document. You want to keep that investigative file well documented, thorough, all those things. You've got this flow chart that's available to you in Title IX that kind of just goes over the procedural requirements that you also, I know, have because you've got templates and things that have been provided to you by Kristen that she'll go over with you and things like that. But just a good reminder, we do this all day, every day and talk about it nonstop, and I still get our flow charts out all the time. I'm still always referring to those flow charts and those checklists. And then just remembering, you're not making a determination of responsibility. And the reason I emphasize that is the same reason I emphasize conflicts of interest and bias as an investigator. Because if you start switching into that role in your brain and believing one party over another, for example, you tend to be less thorough in calling in witnesses on behalf of one party or another, less thorough in asking all the questions. You will tend to subconsciously shut down with that person. And so we want you to just constantly remember you're going down that pathway of the investigation. You're turning over stones as you go. You're looking at them more closely when you need to. You're putting them back down when you don't. We're just doing as thorough of a job as is possible. That's why having a team of 3 is great. Okay, when we come back, we're going to go through the advisor's role. It's just a couple of slides, and then we'll get into our first typo. But I want to give everybody a minute or two to, take a breather. So let's come back at 35 after the hour, and then we will address any questions, answer any other question, go through these last slides, and then we'll get into that first hypo. So I will see you back here in about 10 minutes.